introduce today's speaker, Matthew Kenefick. Matt is a partner at Jeffer, Mangles, Butler, and Mitchell LLP. He has an extensive law practice, which includes litigation, real estate, and compliance matters. Mr. Kenefick represents a variety of industries, including manufacturers, financial institutions, retailers, real estate developers, wineries, and the hotel industry, among others. Mr. Kenefick is the hiring partner for JMVM San Francisco office. And now let's get started, Matthew. Over to you.
Great. Thank you, Hillary. Hello, everybody. Pleasure to meet you virtually. Thank you for taking the time. I'm here to talk about today accessibility laws and trends. So I have a PowerPoint slideshow, which I will share here. And go ahead and get the screen shared. Give me 1 second here. Boy, there we go. Okay. All right. So now everybody, you should be seeing my PowerPoint presentation for today. And it's in presentation mode. There we go. All right. So all right. So we're going to talk about the Americans with Disabilities Act, which is commonly referred to as the ADA, and some correlating state laws in a variety of contexts. So let's talk about the history of the ADA. So it's the Americans with Disabilities Act of 1990, although it does have effective dates of January 26, 1992 and 93. It's title for 1990, and it's a Civil Rights Protection Act. And that's important to note because civil rights acts are construed broadly, as you know. Courts will look at it as a remedial act and remedial measures and try to construe the laws broadly towards compliance and accessibility. And that basically, the benefit of the doubt goes in favor of access. The idea is to provide a full and equal opportunity to persons with disabilities to participate in society. Prior to the ADA and before accessibility focus, we have a lot of people who were unable to participate in what we would consider just daily life activities. People who are unable to go to a restaurant, by way of example, because they use a wheelchair for mobility, and maybe that restaurant has a set of stairs. Maybe people are unable to go to a movie theater with family members because of other barriers and issues. The idea is to allow everybody to have full participation. And certainly that is a noble cause and a noble idea, especially given that a large percentage of our veterans, by way of example, have disabilities. As our population gets older, we see more people with disabilities. Certainly, you would want to be able to participate in daily activities with your loved ones, and that's a noble cause. We'll also talk about some abuses of the laws or perceived abuses in forms of litigation. So there are many sections of the ADA. Title I, that pertains to employment. Title II, government agencies, public services. Title III, which we're going to focus on today, is public accommodations. Title IV, we have telecommunications, basically telephone relay services, things like that. We can talk about that as well. It's communicative access. And Title V, which is miscellaneous provisions. So Title III of the ADA requires public accommodations to provide full and equal access to goods, services, privileges, and facilities. Now, public accommodation is generally any place that does business with the public. Examples that the statute includes goes from hotels and places of lodging to food service establishments to places of entertainment, places of gathering, stores, services, health spas, bowling alleys, golf courses. Often we will find that even some places which are not generally open to the public, such as private clubs, do transform into public accommodations when they're used for public purposes, such as maybe a wedding. Maybe there's a political gathering or event that's used or open, and then we will transform what would ordinarily be a private club or a private place into a public accommodation. But as you can see, this is a very broad list. And the idea, of course, is to extend to anything that basically would affect people trying to use or take advantage of the privileges that are available to persons without disabilities. So what is required? Well, one aspect of the ADA is physical access. Physical access refers to physical construction features that we would see in a place of public accommodation, something something that would affect persons maybe using devices for mobility, maybe certain things such as signage for people who need braille signage, etc. And so the idea is that a new facility, that is something that's built after the enactment of the ADA, after January 26, 1992, that must be constructed in compliance with new construction standards. Now, we have different construction standards. They're actually pretty straightforward. They're housed in the Code of Federal Regulations, and what we have is the 1991 Americans with Disabilities Act Accessibility Guidelines, and then we have a 2010 Americans with Disabilities Act Accessibility Standards. Those are the federal standards. They're pretty straightforward. Like I said, they'll give you maximums and minimums for ranges, for dimensions, etc. The key is there is a lot of case law that does say that a maximum dimension is truly meant to be a maximum. A minimum is meant to be a minimum. They need to be strictly observed. However, there is a little bit of wiggle room on that for dimensional tolerances for field conditions. Some things just cannot be achieved with the precision that's required to meet these standards. By way of example, an asphalt pavement or asphalt area that may not be as able to be as smooth as a concrete piece of paving, and under that you may very well find like a 2% cross slope. For asphalt, you may have a little bit of dimensional tolerances for field conditions, maybe a 1.9 or a 2.1, as opposed to something that has lesser tolerances, like I said, like a concrete area. Now, this includes alterations, meaning any altered element, the entire altered element needs to be brought into compliance. And there's a lot of discussion about this in case law. So what is an alteration? That's a modification which affects usability. So I could have a pre-existing facility, and then I could alter, let's say by way of example, a transaction counter. That entire altered element, the transaction counter, would need to be brought into alignment with the new standards. Whereas if it's a pre-existing facility, we'll talk about that in a second, we have readily achievable access barrier removal. So you'll see here there's a bullet point for Title 24 of the CBC. Title 24 of the CBC is the California Building Code, and it's Section 11 of that relates to accessibility. So while the ADA it only requires new construction to be in compliance with the guidelines, and we have readily achievable access barrier removal, which we'll talk about for pre-existing facility. The California Building Code, as you hear the term grandfathering, what that means is you must comply with the then applicable version of the CBC, or the California Building Code, when you construct or alter an element or a facility. That's updated triannually. The building code's updated every 3 years. And that is important because the California Building Code, in certain respects, we'll talk about in a second, they're more stringent in some respects than the ADA. And the law is you must comply with the more stringent of the two regulations. And keep in mind, violation of the California Building Code could trigger other types of California laws, which then in turn could trigger an ADA violation. So when you alter an element, you're not only going to have to, or you do a new construction, you're not only going to have to comply with the ADA guidelines, but also the building code. We see this manifest in facilities that are based on a national prototypical design. So by way of example, let's say I have a brand that has maybe 1,200 stores throughout the country. They want consistent branding, of course, consistent trade dress. So what ends up happening is these facilities, they will have one set of architects do the designs, and they build it, generally speaking, with the accessibility of the federal standards in mind. What happens though is if they don't have a site adapt architect who is licensed in California or familiar with the California laws, there's a chance that they may miss some of these California nuanced issues. I worked on a very large stadium remodel once, and during the plan review, the site adapt architect had found many changes that they needed to make for accessibility that were not previously incorporated by the national design team. So it's really important to look at it from a California perspective because there's little nuances, and the plaintiff's bar is very well aware of those nuances, and it's usually the first thing they go after. The next thing is the readily achievable access barrier removal. So what this is if you have a facility that predates the ADA, that means it was built, constructed is the term, before the ADA. The constructed term can either refer to a certificate of occupancy or final building permit sign off. But if you have that situation, then you only have to remove barriers when it can be accomplished without great difficulty or expense. That's the standard. And it takes into consideration the overall financial well-being of the public accommodation. You also get to take into consideration safety and security measures. By way of example, it may not be readily achievable to do something, to make a change if it's going to create a safety hazard. But generally speaking, we see that this is, for the most part, is construed pretty broadly. By way of example, in New York, in the Southern District of New York, we have a lot of legacy buildings, legacy facilities that have big stoops or steps to enter into retail facilities. It's an issue. So how would you deal with that? Well, one way you could deal with that is you could create a policy, by way of example, that allows the staff to come down and meet the customer at the street and bring them goods and services that way. And because you could argue that it's not readily achievable to alter or change those stairs. But some courts in the Southern District of New York have held that it's readily achievable to require a stair lift to be put in place. And some of these stair lifts can cost, a lot of money, up to $100,000, sometimes more. And that's been held to be readily achievable. So it really depends on where you're at, but the argument you'll usually hear from the plaintiff's bar is, look, the ADA has been around, for 30 plus years. Your client's had a lot of time to get its facility, into compliance, and all those investments can be amortized over the years. So looking at what is required, we also see that there's a policy and procedure element of the ADA. And what we see there is that public accommodations must make reasonable modifications to their policies, practices, and procedures when reasonably necessary to provide full and equal access. This is a catch-all. We see the DOJ latch onto it a lot because this could pretty much encompass just about anything that you're looking at. So if somebody makes a request for a policy modification, the facility must grant it when it's reasonable. So that's a determination. The term is reasonable, but you could very well see a lot of that manifesting in a lot of different ways. By way of example, that the the stoop issue that I was just talking about in New York. So we're under the ADA, when something's not readily achievable, you can provide equivalent facilitation using alternative measures. That was the policy I was talking about. But you very well could have a customer saying, I want as your policy modification to provide provide me services at the street if it's not readily achievable for you to make the entrance accessible. That that would have to be determined whether it's reasonable, and then it would have to be issued. We've seen this go back. One of the famous cases that went to the United States Supreme Court, it was the Casey Martin PGA case, where he wanted to use a golf cart as opposed to walking. So another area that we see that's required under the ADA is a communicative area. This is auxiliary aids and services. Another category that could be used as a catch-all. And what it is a public accommodation must effectively communicate with its guests and patrons. So the effective communication is the key term. And when auxiliary aids and services are required, the public accommodation must provide those auxiliary aids and services reasonably necessary to achieve that effective communication at no cost to the patron or guest. Examples could be a Braille statement. You could imagine somebody who's a Braille reader requesting Braille statements for their bank. Qualified interpreters, somebody to interpret a conversation or a presentation, note takers, video text displays, screen reader software, etc. Now, the public accommodation gets to make the decision. However, if this were a government agency, such as Title II of the ADA, they must give primary consideration to the requested auxiliary aid and service. There's a lot of companies who provide a lot of auxiliary aids and services out there. As technology matures, we're seeing less and less reliance on this. Most people have just about every auxiliary aid and service that they need available in their smartphone or tablet, but we still see these requests often. So then we talked about California laws, and it's important to juxtapose the federal law versus California law, not just because we're in California, but because there are very important differences. One of the differences we'll see is the UNRRA Act, which is the California UNRRA Civil Rights Act. That has under Civil Code 51F an incorporation of a violation of the ADA. So you'll often see in the complaints an allegation that the defendant violated, when I say complaints, I mean lawsuit complaints, they violated a section of the ADA that triggers a violation of the UNRRA Act, and therefore, as a result, they're suing under the UNRRA Act. And that's important to note. Plenty of attorneys have tried removing cases over the years and have successfully removed cases that were filed in state to federal court. However, there is ample case law or precedent, at least at the district court level, especially in the Central District of California, which is Southern California, Los Angeles area, where many judges have found that a 51F violation does not support a removal or federal question jurisdiction. So what does the UNRRA Act afford? It affords a minimum of $4,000 per incident of statutory damages. That's a minimum. Incident, is defined basically to be, a visit to a facility. It can't be every single barrier that somebody encounters. You can imagine somebody goes to use the restroom at a restaurant. They encounter 30 different violations of law. That's not 30 incidents, but that $4,000 is a minimum. And the highest I've seen was $150,000 for one incident. It was a case that went to trial. And this, I believe it was I think it was Central District of California, Santa Ana Division, and it was over a policy that was facially neutral but had a discriminatory impact. At least that's what the jury found in in the the ADA case, and which does raise an issue. There's traditionally not a jury afforded under the ADA, but there are other statutes that do get you a jury. But anyway, that case, there was $150,000 for that one incident, plus the attorney's fees, which I understood were in excess of $200,000. Now, for physical barriers, as opposed to policy or communicative barriers, California has added that there's a requirement that the plaintiff can demonstrate that they suffered difficulty, discomfort, or embarrassment, or they were deterred from visiting the facility by reason of knowledge of the barrier. And what that means is the deterred, they'd actually have to say that on a specific date, they would have went to the facility, but for their knowledge of these barriers. The difficulty, discomfort, embarrassment, there is Superior Court precedent and also district court precedent, lower level precedent, not appellate precedent, that holds that the difficulty, discomfort, or embarrassment needs to be more than just a hypothetical injury. There needs to be some type of manifestation of physical or emotional harm. One case, by way of example, the Mundy through Pro case, the individual could not see the reflection in a mirror in, if I recall correctly, a gas station. It was mounted too high. But they ultimately were able to see the reflection in another reflective object and fix their hair or whatever they were trying to do. And that didn't rise to the level of difficulty, discomfort, or embarrassment. There was another case, I believe it was the plaintiff was strong, and I think this was a Southern District of California federal case, and it was found that a plaintiff, the striping and the path to travel in the parking lot was not correct, didn't have a correct path to travel, but the plaintiff nevertheless was able to successfully traverse the parking lot, and as a result, that didn't give rise to the difficulty, discomfort, or embarrassment. There are a variety of conditions that for certain types of businesses that can show there's a presumption that difficulty, discomfort, or embarrassment was not met, such as faded striping, if I recall correctly, or signage wording being a little bit off. All that's housed in Civil Code Section 55.56. Now we see the Disabled Persons Act. That's a little bit different. It gives $1,000 per incident statutory damages. There's an interesting case out there, a California Supreme Court case on it, in fact, that held that if a plaintiff seeks their attorney's fees as an element of damages, which they're entitled to under the ADA, the UNRRA, Civil Rights Act, and the Disabled Persons Act, but if they seek it under the Disabled Persons Act and they lose the case, then the defendant could obtain their attorney's fees. So you'll usually see the attorney's fees prayer only under the ADA or the UNRRA Act. I talked briefly about the differences between the California Building Code versus the Americans with Disabilities Act. We'll see by way of example, counter height, very common one. The federal standard is 36 inches above finished floor for a transactional counter. We have 34 inches as the California standard. That catches a lot of people. We have ATM scoping by way of example. That's the number of accessible ATMs per location that's being required. California uses westernized Braille, which is a different type of Braille than the federal system. Although less and less people are using Braille these days, used to be primarily people who were congenitally blind, people born with blindness, but now just due to the massive availability of auxiliary aids, we have screen reader technology. Most people have phones that can help with accessibility. There's less of a reliance on Braille. Now, the UNRRA Act, unlike the ADA, is not limited to public accommodations. It extends to business establishments of every kind whatsoever. It's intended to be interpreted as broadly as possible. One thing to note that this does apply to the sale and rental of housing. The UNRRA Act also, by way of example, has a broader definition of disability. The federal standard is a substantial limitation on daily life activity. The state definition is just a limitation on your ADL, your activities of daily life. And that can be construed very broadly. It does not take into consideration people who use aids. So by way of example, if somebody is able to walk with a cane, but they're unable to walk without a cane, we look the way the law construes whether or not a person qualifies as having a disability sufficient to impact daily life activities. They look at it without the assistive device. So one thing that's very popular is websites. We see website accessibility is a very hot issue in litigation. We see that a lot in California, a lot in New York. Some of the most prominent filers are in New York. Florida used to be a pretty dominant, and that's gone away a little bit just because of some of the case law changes, but it's still present. We see it in Pennsylvania. There's a couple law firms who specialize in website accessibility. They file in Pittsburgh. There's a very plaintiff's favorable process in Pittsburgh, the federal court there. So we see it all over the place. So generally, many courts have considered websites to be places of public accommodation, with a lot of precedent going on towards this. Depending where you're at, depending on the jurisdiction, some courts require some type of connection between the public accommodation and the physical place of the public accommodation and the website, whereas other places, other jurisdictions have ruled pure internet only websites, something that only exists in cyberspace. It constitutes a public accommodation. And obviously the state laws that we're talking about, such as the Unruh Civil Rights Act, get bootstrapped. So people say, all right, well, your website's not accessible and you owe us $4,000 minimum per incident for the website. There is a standard out there. It's unlike the physical standards that we have, which are pretty clear. We have conceptual guidelines put together by a private organization called the World Wide Web Consortium. They come up with these web content accessibility guidelines. These are not federally adopted for public accommodations, but the Department of Justice has relied on it heavily. A lot of judges have adopted it. In California, it has been held to be persuasive evidence of non-compliance with the ADA, showing basically that a website is not accessible to persons with disabilities. A manifestation of that by the failure to comply with the WCAG. Right now, 2.2 is the standard. There's three different success criteria factors: level A, double A, triple A being the most stringent, single A being the most lenient. Double A is pretty much what most people go for. What happens with triple A is the websites, the functionality gets significantly decreased, and nobody wins that way. But we also have found that, or some courts have found that it's well within their equitable powers to order remediation to the WCAG standards as part of their injunctive relief. Website claims, they're easy to file. We get a lot of people just serve demand letters, some people who actually file suit. California has restrictions on certain types of demand letters that can be made. Some attorneys have gotten in trouble. The primary restrictions do relate to physical access, but for website access, some of the concepts still pervade. By way of example, there was one attorney in connection with physical access who had his admission to practice in the Central District suspended, I believe, for 1 year, because in his demand letters, it was found that he was giving legal advice to the purport, the defendant or the target, basically saying, look, you should settle with me. You shouldn't involve a defense attorney who's probably just going to make a big deal out of the case. And you have a losing case, you should just settle, something along those lines, generally speaking. And the court found that to be improper. And like I said, the physical demand letters, if they seek money, it's supposed to, they're not supposed to seek money, and it's supposed to be recorded with the judicial council. So what usually ends up happening is most people file suit first. Now, the website access cases are really easy to find. Imagine suing somebody over a physical facility. If somebody's getting sued over a physical facility, you have to go there. Somebody with a disability may not be that mobile. Getting them over to the facility, and having them actually encounter the facility as a true legitimate consumer with an intention to return, which is important for Article 3 standing if they intend to sue for injunctive relief. For that, that's a lot more difficult than just clicking on a website. The websites are, generally speaking, we see a lot of automated testing. So what does that mean? So there's a lot of automated tools out there that can be used to determine whether or not a website complies with some of the WCAG standards. The automated testing has flaws. Nothing's perfect in this world, including automated testing. They get a lot of false positives. They also miss some things, and there's a lot of different tests out there. That's used a lot by the plaintiff's bar. In fact, I often recommend to my clients, if you're looking strictly to minimize litigation exposure on your website, run the automated testing and run the free ones that are more likely than not to be used by the plaintiff's attorneys. You don't want to use the most sophisticated one that they're not using. Your goal, certainly you may have the goal to make your website accessible, but if you're also looking at minimizing litigation exposure, the key is you want to be looking at through the same lens that the plaintiff's attorneys are. And that means that if you find false positives on that automated testing, fix those false positives. Even if your website is accessible, fix those false positives, or you may end up getting sued and having to pay an attorney like me to deal with convincing a plaintiff's attorney that there is a false positive. And the plaintiff's attorneys are not that easy to convince. So once they are very creative, most of them will settle for a commitment to remediate the website and a settlement value that costs less than what a nominal defense of the lawsuit will be. So it makes it very easy to settle with them. We often find that plaintiffs' attorneys will target an entire enterprise, a business enterprise, because it's very simple. You find a problem with one website, it's probably going to be on the sister websites because there's a common development team. One of the problems we do see is a lot of offshore development teams and contractors who may not have a focus on the accessibility component. And one thing that's very positive is most development teams these days, historically they have lacked the capacity to achieve conformity, and we see that. But most development teams these days, accessibility is getting on the radar. And if you provide them some automated testing or a plaintiff's report, preferably you're proactively doing with automated testing or use case testing of your own. That's where you have a person with a disability using a screen reader technology. They go and they try to use your website and they tell you what's wrong. If you provide it to them, a lot of teams, more development teams these days are able to help you with that. Like I said, we usually have claims that are bootstrapped with damage claims. New York and California have damage claims. The New York statute's much smaller in damages, but California does have damages as well. One of the things that comes up for retailers is holiday code lock. We see a lot of retailers that once they get towards the holiday season, nobody touches that website. You're not going to be able to fix that website until after holiday season is passed. It's a big piece of their revenue. E-commerce is huge. You're not going to get You're not going to be able to go potentially crash a website by making accessibility changes. Most people do a pilot anyway in a closed environment, but still, code lock is a issue. Third-party content procurement is another issue. Not all the content you'll find on websites is developed or hosted, for that matter, by the public accommodation. Some of it is linked or deep linked. Some of it's embedded. Some of it, such as pay transaction, point of sale transaction aspects, that's created by third parties. And the issue with that is their software, it's their website component. You may not have the ability to make the alterations yourself. One thing that's important is do a public-facing website accessibility policy. A lot of people get dinged on that. Every Department of Justice consent decree I've looked at has always requested and required that. So it's really important to do that. And basically, it's just stating a commitment and stating the company's commitment or restating the company's commitment to accessibility to the public, and equally fundamental, giving some type of channels for channels to be able to make any type of complaints or requests for accessibility issues. That's an important issue as well. I think it's important to track any complaints because it's a great way to prove a negative. If you have an accessibility complaint channel and somebody comes to you and sues you over website access, and you can show that, look, we track every single complaint and we've never received any complaints over the issue you're talking about. That's good persuasive evidence. It's not conclusive evidence, but it's persuasive evidence. And one of the things we have seen is in Department of Justice enforcement, we have seen that first thing they ask for is, tell me about all the complaints you received over your website, right? Or over whatever component you have of your accessibility. And again, it's a good way of proving a negative. The last bullet point here, remedial access vendors. I mentioned up above a lot of development teams historically have lacked the capacity to achieve website conformity. And that's where there are website specialists or remedial access vendors who specialize in helping you bring your website into compliance. We talked about the W3C that creates the standards. We also talked about the WCAG. Again, it's more of a conceptual guideline. It does have very specific issues with some guidance for some specific issues, but still, goes on the principles of perceivable, operable, understandable, and robust. It's there. A lot of things we find that it's not as cut and dry on how to achieve access under the WCAG as you would with the physical access. Just says, look, your transaction counter needs to be 34 inches above finished floor. So there are a lot of free tools you can do to assess your website's accessibility. These are those automated tools. Again, Plain as Fars use these. The Wave tool. This can also be used as a plugin for your Chrome browser. A-Checker, accessibility checker. The company DayQ, that's DEQUE. They have a tool called the AXE, the Axe Dev Tools. I like that tool a lot. They have a free version and a paid version. So it's for a little bit more sophisticated of a user. You can open up the development panel in your browser, and you can use that tool to specifically identify offending code, give you WCAG references, and suggested fixes. It's a very powerful tool for the more sophisticated users. Again, these are automated tools that, if you truly care about achieving accessibility, use case testing is very important. So some low-hanging fruit issues we see on websites. It starts off with just an understanding of what's happening here is where I use a mouse. I use a graphic interface on my computer. Somebody who is blind, low vision, or has other types of disabilities which impairs their ability to use and navigate the computer may not have access to or ability to use a graphic interface. So imagine going through a screen or a website without a mouse. And what happens is they have screen reader technology that will read highlighted or focused on portions of the website. So you change focus to headings, other items, right? And that will read out loud to the person who doesn't have use of their screen. That's the screen reader technology. It's one of the many tools that WCAG's intended to make websites accessible to be used with. And so when you have this screen reader technology, people are navigating with the arrows or the tab button. One of the things they go to is the heading structure. Heading structures are very important to organize content for screen readers. So it's important to have appropriate heading structures. Alternative text for images. So what alt text means is when I see a picture, by way of example, of a tennis shoe on a website that I may like, and I may want to purchase it or just know that I'm looking at it. Somebody who doesn't have the ability to see that screen, how do they know that the focus is on a tennis shoe? Well, you have meaningful descriptions, alternative text that will say, this is, a picture of a brown Nike tennis shoe or whatever is there. That's alternative text. And it's important to have meaningful alternative text. Often we'll have, categorical description. You could say, by way of example, it could be a retail item, as opposed to a tennis shoe or a lipstick or something along those lines. And what we do find can be a challenge. It can be a real challenge for websites that have a lot of products or changing products. Websites can often be updated, daily, multiple times a day. And if you have a retail website that may have thousands of items on it, certainly alt text can be a challenge. Color contrast is another issue. You'll see a lot of high contrast on here where it's black text on a white background. But you can imagine if this was a gray text on a white background or a silver text on a gray background. That contrast would be very light and it'd be very hard for people who have low vision to read. Color contrast is something we see a lot of in complaints. Of course, the counterpoint is somebody who is blind probably should not have standing to assert a color contrast complaint because they're not seeing the screen at all. Again, we want to make sure the screen is navigable by a keyboard. And then we talk about, and this is another one, it's another slide, but captioning for videos for people who are deaf or have hearing impairments. These are just some low-hanging fruit items that we see people sue over a lot. So, a way of reducing liability is, we like to conduct regular accessibility testing. Some companies will automatically test for you if you set up on a testing interval. You could also do it yourself, just using the tools we talked about. Just make sure that your website remains in compliance. Just because it's in compliance today doesn't mean it will be tomorrow. Things do change. Another thing is you can bring in third-party consultants to give you advice on how to bring your website into accessibility. Anytime you alter a website, you should make sure all new content follows the WCAG guidelines. Another thing is if you do have on-site development teams, make sure there's training. Make sure there's development guidelines that are memorialized. It's a good idea to have somebody who has ownership of the accessibility features of your website. You may not need to hire an accessibility coordinator, although most consent decrees do request that or do require that. Nevertheless, you should have one person of your development team who ultimately has ownership and responsibility of that. It creates a good defensible policy for accessibility. A lot of websites, they use templates, meaning that one page of your website is going to be on the same template as as another one. And the importance of this is make sure you waterfall the changes throughout all your templates. And if you have problems identified, just know that you should check your other templates, especially if you're using similar templates across an enterprise. Some pitfalls to avoid: software overlay. So there's a lot of brands out there who Level Access, Accessibility, AudioEye, DQ, they do provide these wonderful tools, which are software overlay. Overlays right now, basically it's a widget or a tool that goes into your website that will create code to interact between your website and a screen reader technology. It's a great idea. Some of them work better than others. The problem is twofold. They're not perfect. There are problems. And it's truly considered right now by the plaintiffs bar not to be a substitute for creating accessible code. In fact, some plaintiffs' attorneys specifically target websites that use overlays. So people may go to a website overlay company getting promised, that they're going to never be sued again, just to make themselves a bigger litigation target. I have had interaction with some of the overlay companies over my clients getting sued, and I have not found tremendous support from them in responding to lawsuits. Basically, you're still on your own. So I've heard a lot of salesy pitches. I've seen a lot of them from some of these overlay companies. Again, the technology is developing, and it's just not there yet from what I understand. I would be aware of when you use third-party development companies who just design your own website, like Shopify, things like that. You just got to make sure that when you're doing that you take ownership and responsibility for the accessibility. That of course can be a problem. We talked about alt text and color. Alt text is an issue that we often see. Color alone can be an issue because there are colorblind users. So it's always a good idea to use additional indicators like asterisks or text labels. Again, color contrast. One of the issues we see a lot is forms, fillable forms. We often find problems with that. Fillable forms, like I said, is often third-party content that's either embedded or licensed to a website. But we do see issues with fillable forms, meaning, by way of example, I'm checking out on a website and I want to enter my address or something like that. That can be an issue. So that's a hot spot to check for. That could often be what's considered a hard stop on a website. So we'll find barriers that may impair the user's ability, but they're still able to consummate a transaction. An inaccessible fillable form could be a hard stop. Again, we like the testing component. I talked about this earlier. I touched on it. Pre-recorded content is an important issue for audio. So if you have pre-recorded content, you should have captioning, unless you can legitimately say that it's just an alternative presentation of information that's otherwise on the website. If you don't have audio component of pre-recorded video content, it's the best practice is to use a statement, such as no sound is used in this clip. Otherwise, captioning is required. Now keep in mind that for live content, you're not required to have captioning because it's not pre-recorded. Other things is, if you have materials and information on your website, that should also be accessible. PDFs should be created, if you have PDFs that can be downloaded, etc. They should have logical structure for screen readers. Videos should have captioning and transcripts. Excuse me. There's a lot of legacy content out there as well. That by way of example, you can imagine somebody who has old contracts or documents in PDF form on their website, such as an insurance company, maybe, right? You can have your old policy documents. That's a pitfall. You could definitely be facing some people coming after you on that. So you may want to convert to something that is accessible. We talked briefly about policies. It's important to have policies that promote accessibility. Keep in mind, policies don't just help you memorialize and train people off of the policies, but it also creates a defensible infrastructure to somebody who's suing you. One of the things that we do see a lot in lawsuits is if it's a federal lawsuit and it's only seeking injunctive relief, something that we see outside of California, an easy way to deal with it would be to try to moot the lawsuit, meaning that if you fix the item that they're suing over, they can't enjoin you to do something you already have done. It renders it moot. In fact, in the Southern District of Florida, one of the magistrates has a policy that says, look, if you file a lawsuit as an ADA plaintiff, the defendant can, before their answer is due, they can confess and say, look, okay, our facility has a problem, or our website has a problem, but we agree to fix it. And then what the judge will do is the judge will stay the case. In that case, that's judge's standing orders, will stay the case for a period of time. And when you come back, if you prove that it's fixed, the judge will give the plaintiff's attorney reasonable fees, but just for preparing and filing the case, as opposed to keeping the meter running throughout litigation. That specific policy has been challenged in the 11th Circuit. I handled that. I handled that appeal to the 11th Circuit, and we were successful. The 11th Circuit upheld that as being within the discretion of that magistrate. But keep in mind that the way that people went off a little bit of tangent, but the way that a plaintiff's attorney can overcome mootness is by arguing, okay, well, I'm not targeting the fact that the facility isn't in compliance or the website isn't in compliance. I'm targeting the lack of policies for compliance. And they try to say your policies need to be remediated. Well, if you have a defensible policy, they can't expand it that way. Again, we talked about complaint channels. We talked about training. It's a good idea to train off your policies, and certainly just think when I create a policy, I like to think about if it was viewed by an outside person, what message would it send? Would it demonstrate the business's commitment to accommodating its customers with disabilities? Is it going to send the right message? We're running out of time, but I'll just go over this real quickly. Emotional support animals. In March 2025, I'm aware of a lawsuit that was filed in Southern California over an open house of a service animal. They asserted Disabled Persons Act claims, UNRRA Civil Rights Act claims, FEHA and FHA claims. I don't know the status of the lawsuit. I think it may have been resolved. But the issue is we have service animals. And service animals are any dog or under federal law, miniature horse, that is individually trained to do work or perform tasks for the benefit of an individual with disability. Compare that to an emotional support animal. An emotional support animal is just an animal that provides comfort to a person with a psychiatric disability, and the animal's not individually trained. We also see guide dogs, signal dogs, and service dogs are all covered not just under federal law, but we also see it under California law. Dogs and miniature horses are under the ADA. You're allowed to ask some questions. You're not allowed to ask others. I usually advise clients not to have any inquiry about this and not to have their staff do any inquiry. Either A, they'll get it wrong, or B, they'll get heard wrong, and a plaintiff will sue you claiming that you asked the wrong questions. Basically, you can ask whether or not they need the animal because of a disability. You can't ask for proof of training or a license. You can't ask them to explain their disability. That's private. You can ask what tasks the animal has been trained to perform. You can't charge a pet fee or a cleaning charge, but you certainly can charge for actual damage. And if there's an animal that's violent and not under the control of its handler, you can have that animal removed. under California law, it is a misdemeanor to misrepresent an animal as a service animal when it is not one. We often see people get these vests. The issue is who provides the training. There are a lot of controversy. A self-trained over this issue. A self-trained animal is still considered. It can be considered a service animal. So certainly you could have a service animal that may not be the best service animal because it's self-trained as opposed to professionally trained. The professional trainers obviously take great issue with this because they spend a tremendous amount of time, money, and effort in training the animals. A lot of the programs I'm aware of actually lose money on training the animals, but they do it as a service, and they're wonderful animals. An emotional support animal we talked about is not trained, and we see this not in a public accommodation setting, but in a housing setting, and also an employment setting. So under the Fair Employment and Housing Act and the Fair Housing Act, we see that there's an interactive process that's required when somebody makes a request to have an emotional support animal. That could be a whole nother presentation in and of itself. Responding to claims, basically, and what a lawyer can do is we identify the barriers, determine if there's any protections, don't retaliate against the plaintiff. There's a lot of local rules that apply. Central District of California, by way of example, you can get a stay and a mediation. Northern District, we have our General Order 56 up here, which basically stays the lawsuit and has the parties try to resolve it. I like to run in two tracks. The first track is fix the issue. Concurrently, the second track is to try to resolve the lawsuit, put out the fire, so to say. There's a big risk of copycat lawsuits. It's very simple for another plaintiff to know whether or not your clients, are willing to make a quick settlement. They see a request for dismissal with prejudice. So that's can put your client on the mark. One of the issues too is we do see that the plaintiffs do switch firms, attorneys switch firms. I say plaintiffs switch firms, literally one plaintiff be represented by one law firm and then switch and be represented by another law firm. So this institutional knowledge will be shared. You just have to presume that if you pay too much or settle too quickly, there's a chance your client's gonna get sued again. Often what I will do as a strategy, if I have a small client never been sued before, that's one approach. But if I have a larger client, has a lot of businesses, a lot of exposure, and they've been sued a bunch, then we're going to try to send the message that we're not a soft target. And that means not settling quickly. Disrupt the plaintiff's business model. Make them earn their money. They make a lot of money in ROI off of refiling the same exact lawsuit over and over again, or saying the same demand letter over and over again, and getting quick settlements. But if you make them do some work, then that disrupts their business model. So certainly slowing down and paying less helps. And disabled access strategy, we're talking about identifying compliance issues, identify action items, certainly prioritizing. Certainly you want to do the low-hanging fruit items first. Some things are more tractable, more difficult to repair. Then you identify certain items. I've had clients who say, look, it's going to cost us way more to fix than our litigation exposure is. We'll do the best that we can to make this element compliant, but we're not going to tear down our building or whatever. And that would be an acceptable risk that they decide. It's a business decision. Certainly create an action plan, and that is the end of our presentation, right at 1:30, which I think is the end of our time here, and we can take any questions if there are any.
I'm actually not seeing any questions at this time. So with that, I'll go ahead and say that this concludes today's presentation. Thank you so much, Matthew, for your time, and thank you so much to our audience. Have a great day, everybody. Actually, look at this. Nadine Lewis asks, what is the test for reasonableness as it relates to policy?
Yeah, that's a good question. So certainly a policy needs to be something that is intended um, to memorialize and further a culture of compliance, right? The idea is you're trying to prevent future recurrence of violations. So reasonableness of that certainly is a case by case basis. Again, I would think it would be something that I would I would try to ensure that it's going to be interpreted in a way that makes sense to the average viewer or reader or user, whether that intended audience is an employee, whether it's a person who's going to be trained off of it. Usually we like to have our policies, something that's onboarded and then resides in your LMS if you have a learning management system. Uh, but certainly we're also going to want to make sure that if it's viewed by an outside agency or a plaintiff, that it demonstrates a commitment um, to achieving it. So we see there's a lot of counterintuitive things that go into policies. Certainly there's an interaction etiquette that most people need to be trained on if they are going to be dealing with persons with disabilities. By way of example, one of the big issues I think is focus. They call it a person first culture, and that is you focus on the person. It's a person with a disability. It's not a disabled person. The disability doesn't define them. Different is not less. So it's important to focus on that and focus on what they can do and assisting them in a respectful and meaningful way. There is a false etymology about the origin of the term handicap, and that can be a sensitive word for some people. We do see the term still in our legislature. Handicap, some people falsely believe that it originates from somebody holding a cap in their hand for handouts, and that referring to persons with disabilities. I've heard that a lot from persons in the disability access community. I've heard people talk about how negatively they view the term. But if you look it up, it actually has nothing to do with that. It actually originates from, at least from what I've read, horse racing and livestock. But nevertheless, it's negatively associated, whether it's correct or not, and therefore, again, that's something that would be in a policy. Training, if you're training people how to have interaction etiquette with persons with disabilities. Likewise, if we're talking about website accessibility, the policy would be, something that would suggest that you have a commitment to promote accessibility, and that you're also going to, on a regular basis, take reasonable steps to ensure that your website is accessible and remains accessible. Again, I've written a ton of these policies over the years. In fact, I have a whole set of elements that I go through on a checklist. They're primarily based on what I've seen in settlements and in the community, but I'll see it in, like I said, you really just look at historical Department of Justice consent decrees to see what people are looking for. So that's, unfortunately, it's reasonableness. All right. So we see another one under the Under Act covering rentals in public as well. It's not public accommodation context. Under Act applies to business establishments, but it does apply to the sale and rental of housing. It does cover senior living, but we also see that extending beyond. We do see that extended beyond the issue of just senior housing. The question is could a family renting out a single home be subject to the Under Act? Remember, it's not public accommodations for Under Act; it's business establishment. But yeah, absolutely. You could imagine a situation. The Under Act proscribes discrimination based on just about any identifiable characteristic. It goes beyond just disabilities. So you could absolutely see somebody who is discriminating against somebody, say, look, I don't, I had a bad experience when I was a kid with blind people. So blind people are not allowed to rent from me. It's my house. I'm not going to do that. They're certainly going to get sued over that. And that is what we saw in a single family home that was offered for sale in a rental context where the listing agent, or not a rental context, residential context, where the listing agent said, look, I'm not allowing you to bring your service animal into this house. Now, keep in mind, just because you're subject to the UNRRA Act or the ADA doesn't mean the answer is always yes. There's a lot, there's a lot of reasons why a service animal may not be allowed into a facility. There's a lot of case law out there about when a service animal is allowed in a pool, by way of example. There's situations where it's just not safe. There's a lot of situations where you're not going to be required to make any facilities. Okay, and so it's not an absolute, but definitely it's subject. So we see another question from Lan Win, and it's for a deaf person who requests an interpreter, is there a required response time? For example, at a music venue? That's a very good question, and I dealt with this extensively. One of the issues is you're supposed to achieve effective communication, right? And that's the auxiliary aids and services. So ASL, American Sign Language, is not English. And in certain types of transactions, if somebody's requesting, let's say, a qualified sign language interpreter, under those circumstances, you may not have one available. And you can imagine if it's a class, a school, a financial transaction, something like that, you're going to need that. So that's where the reasonableness of the request comes in. And the reasonableness of the request means reasonable lead time. Somebody shows up on site for an event that's occurring in 2 minutes, and they say, look, I want a qualified interpreter, or I want a real-time display. It may not be a reasonable request just because the lead time. I often suggest that you include in any materials, any request channels. And if you do a little bit of research, find out from your local agencies, if you're putting on a big event, find out, local agencies, how long it's going to take to get the resource, the common resources that are requested, such as an interpreter. And then put the lead time. Look, we need 48 hours advance notice, something like that. If you can't come up with the advance notice, you cannot, the actual amount, it just has to be reasonable. But certainly, we have encountered this where people have tried to figure out what is the appropriate advance notice. And of course, it depends on the circumstances. Certain areas, by way of example, you talk about Disneyland. Disneyland's in Anaheim, Orange County. You got a lot more, you probably have a lot more resources available, a lot more people who come out and work for you than if, let's say, by way of example, you're in some rural part, or some remote isolated area where you're not going to have, there may only be one interpreter for the whole town, right? So certainly it's a reasonableness of the request, and lead time is absolutely acceptable. So, but that definitely, that goes into the qualified or the auxiliary aids and services, which we do see a lot. And along that line of the communicative access, I will just mention, I touched on it briefly, but I didn't really go into it. I know I'm going a little bit over, but it's the TRS, the Telecommunications Relay Services. It's a different section of the ADA, but it was a very hot topic about 10 years ago. What it is we have, so for persons who are deaf, have a hard time speaking, hard hearing, they'll communicate with text, either through a teletype device or through a chat, just like we're using here today. So when they want to talk to somebody through a telephonic channel, that can be a challenge. If you're deaf, how do you call somebody? If you're deaf, how do if you have a speaking disability, how do you make a phone call? Well, we've all heard about the teletype devices, which basically looks, like an old school like speak and spell when you type it in. And that's one channel. But there's another channel. The other channel is 711. It's a service provided by the FCC. And what it is, it's provides telephone relay services. So the person either through a computer chat or a teletype device contacts the agency. And what they have, it's a governmental provided agency at no cost to U.S. citizens. So that's people who are residing in the U.S., maybe not citizens, but U.S. residents, people residing in the U.S. or people who are abroad who are U.S. residents, and they make and they give advance notice that they're going to be traveling abroad. And the issue is they can contact and communicate with this person who's a communication assistant. It's basically an operator, and they're talking to them via the text message. Just like I was reading that question, they read the questions, and then they make the phone call for you. The problem is you could imagine the anxiety that a call center operator receives. Imagine you work for a bank and somebody calls you up and says, look, I'm actually not your banking client. I am a third-party communications assistant, and I'm calling you on behalf of this person. And any verification or authentication questions you have, you pose to me. Give me a little bit of time. I'll type it to them. They'll type it back to me, and I'll give it to you. You want that PIN? Sure, I'll give it to you. It's going to wait a second. All kinds of fraud alerts go off. The DOJ, in enforcing those rules, they said the fraud falls on the public accommodation. You have to deal with the fraud risk. You can't turn away. You can't turn away and shut down telephone relay services. Wells Fargo was one of the ones that got hit pretty hard. I believe they ultimately were their penalties were between $15 and $20 million that they had to pay and then make major changes. So that is something else that's out there. It's a little bit more obscure these days because most companies prefer to use chat communication channels as opposed to telephonic channels. But if you do have a customer or client or a contact or even yourself that uses a telephonic channel exclusively, that is an ADA risk. So, all right. Well, I think we ran out of questions. I appreciate everybody's time and patience, and we tried to get through all the slides.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.